I'm Katie, and I'm currently taking the Real Estate Pre-License course through Metro Brokers Academy School for Real Estate. I want to invite you to study with me on my channel. We will review all the chapters individually, as well as the vocabulary you need to know within each chapter. So don't forget to like and subscribe at the end. Without further ado, let's move on to today's topic. Real Estate Exam Prep, Agency Review, with Katie Landers Does Real Estate. Before we get started, let's take a look at today's outline regarding agency and all the things we will be covering. You can find this outline in the description below this video. After we review this chapter, you can also look forward to a chapter quiz and vocabulary, so don't forget to subscribe. Let's get started. The Common Law of Agency. The common law of agency is a body of common laws that surrounds the situation when the principal delegates to the agent the right to act on their behalf and to exercise discretion in doing so. The nature of agency in real estate is where the brokerage firm is the agent. The principal or client authorizes another person or entity to act on their behalf. The agent acts on behalf of another and engages with the third party or customer. The relationship between principal and agent is one of trust and confidence, where the expectation is the highest possible level of competence. A fiduciary relationship. The payment of commission does not create an agency relationship. Parties entering into an agency relationship must clearly understand the two basic factors affecting liability that are inherently in agency. The principal becomes accountable for the agent's words and actions, whether or not authorized, and an agent owes absolute loyalty to the best interest of the client. There are three types of agents, classified according to the amount of authority they are given. You have the universal agent, who is authorized to perform any act the principal can perform. Then you have a general agent, who has the authority to bind the principal in the ongoing conduct of a particular business. You have special or limited agent, who is appointed for a particular purpose or for a particular occasion. The implications of agency law are involved in almost every aspect of real estate business. For the listing, the property owner is principal and the broker is the agent. The buyer-brokerage agreement, the buyer is the principal and the broker is the agent. For license affiliation, the broker is the principal and the licensee is the agent. Creating an agency relationship. Types of agency. You have actual agency when parties to the agreement have entered into a relationship intentionally, whether in writing or verbally. You have ostensible agency when a third party relies on the principal's express or implied representation that a particular person is his or her agent. And you have implied agency. Word or actions cause the person or buyer to feel the agent broker are acting on their behalf, when that is not the agent's or the broker's intention. You have power of attorney, which is a written instrument which authorizes a person, called an attorney in fact, to act on behalf of the one granting the authority. You have implied authority, which is authority of an agent arising from custom rather than expressed agreement. And you have the amount of authority. The agency contacts must be specific about how much authority the agent is to have. And the principal. The principal is not liable for the agent's acts beyond the scope of the actual or ostensible authority. The principal has to be careful not to ratify the acts. Ratification can happen particularly when acts are done in their presence. Now we go on to agent's obligation to the principal. When representing the principal in a fiduciary capacity, the agent has these duties. We can remember them by Poland: personal, performance, obedience, loyalty, accountability, notice, and due care and diligence. Let's take a look at what each one stands for. A principal selects a broker on the basis of trust and confidence, so he or she is entitled to expect performance. An agent must obey the principal's instructions unless asked to do something unethical, illegal, or unreasonable. Now, for loyalty, we have the principal's interests must be placed above those of anyone else, including those of the agent. As for accountability, the accountability really speaks for itself. The agent must provide accountability. Notice, broker's duty to the principal includes full disclosure in any matter that might affect the business at hand. Due care and diligence is real estate licensee must exercise the degree of care a prudent business person would employ in a similar situation. Now let's talk the principal's duties to the agent. Indemnification. The principal is obligated to indemnify the agent against any loss suffered through no fault of the agent. So again, indemnification. The principal is obligated to indemnify the agent against any loss suffered through no fault of the agent. Performance. The principal must give an agent a reasonable amount of cooperation and assistance. For reimbursement, the broker reimburses the agent for approved unrelated expenses. In compensation, the principal owes the broker compensation upon performance. Okay, now termination of agency agreement. We have 10 of these. We have performance, which is the agreement ends when the purpose for the agreement is no longer exists or is no longer possible. Expiration, if an agreement has a time limit, it ends when time runs out. Revocation, when the principal can terminate an agency agreement but might be held accountable by the agent for services performed. Reunification, an agent can terminate an agreement but might be held accountable by the principal for breach of contract if there is no justifiable reason. Abandonment, if the agent makes no effort to perform, a principal can use abandonment as a valid reason for revocation. Agreement, parties to an agency contract can end by mutual agreement. Death, if either of the agent or the principal dies, this ends the agency agreement. Incapacity, if either party declares bankruptcy or is judged legally incompetent, the agency agreement ends. Supervening illegality is a change in the law that makes some performance in the agency contract illegal. Extinction is the agreement ends with destruction of subject property. Agent's obligation to the third parties. Reasonable skill and care. The agent cannot be careless or incompetent. Accountability. Must account for all monies and valuables. Honesty and integrity. Must always provide factual information free from fraud and misrepresentation. Truthful information regarding the property that may affect the value or desirability must be disclosed to third parties. Patent defects are visible and can be easily discovered through an ordinary inspection. For properties that have been the site of a death, homicide, suicide, rape, or other criminal activity could cause the property to be stigmatized. In this case, the law states that if asked about any of these occurrences, a licensee shall answer truthfully but is not required to volunteer that information up front. Affiliation Agreement. Brokerage business is the sole proprietorship. Single owner runs the business and is personally liable for the business. Partnership is an agreement must be filed. Each general partner is personally liable for the business losses. Corporation is considered a separate person by law. It eliminates personal liability. It has perpetual existence and raises capital through stock offerings. S corporation is a cross between a corporation and an LLC. It has the pass-through tax benefits and offers shares 75 stockholder maximum. LLC does not have perpetual existence. Personal liability is limited and taxes pass through to the members. Now for brokerage responsibility, the salesperson owes their broker absolute loyalty. The broker, in turn, is responsible for all of their actions within the scope of the business. Relationship between broker and salesperson. Employee. The broker has more control over the affiliate's activities. Independent contractor and business for themselves. They are accountable to the broker for the work performed. For compensation, the employment contract specifies how the salesperson will be compensated. It is typically based on a percentage of sales. And for the agency policy, the broker is responsible for determining the company's policy regarding agency relationships. Now on to the listing. The listing is the broker's contract of employment with an owner authorizing the broker to find a buyer or tenant who is ready, willing, and able to meet the owner's terms. Now we have a couple different types of listings. We have an open listing, exclusive right to sell listing, and a net listing. The open listing is an express, unilateral, executory contract where an owner promises a commission to a broker who produces a ready, willing, and able buyer at the named price. The owner can have as many listings as he or she chooses, even with no obligation to pay any broker. The broker makes no promise to seek a buyer. The open listing can be written or oral. The exclusive listing is an express, bilateral, executory contract where only one broker is authorized to market the property, but the owner reserves the right to sell it him or herself with no obligation to pay commission. The broker promises to seek a buyer here. For the exclusive right to sell listing, it's an express, bilateral, executory contract where the broker receives maximum protection because the right to market is exclusive and the commission is assured if the property sells, no matter by whom. So even if the owner sells it, it still goes to the broker. This is the most widely used contract. As for the net listing, the results are when a seller has a certain sum in mind that he or she wants to obtain from the sale and authorizes the broker to market the property at any price and pocket the difference. Multiple listing. Multiple listing, or MLS, is not a type of listing but an organization of brokers who wish to share information and solicit the cooperation of other members in marketing their listings. There is an express or implied agreement to share commission earned by cooperating efforts. Now for the termination of listing, listing is a contract and can be terminated like all contracts: performance, mutual agreement, breach, and expiration. The listing presentation. 1. Prepare to recommend a realistic price by researching data and comps, which is your competition. 2. Explain the broker's agency policy. 3. Present a marketing program, discuss showings and how to make property show best. 4. If possible, obtain a copy of the seller's deed. 5. Explain why structural defects must be revealed to prospective buyers and why offers are subject to home inspection or due diligence period. 6. Have the seller sign a form authorizing the licensee to obtain information about any existing loan from the lender. Right to a commission. In a listing agreement, the seller agrees to pay the broker a commission once the broker has performed according to the terms of the agreement. In case of a breach, the broker must prove valid real estate license holder, have a written agreement, prove procuring cause in cases of non-exclusive agreements. Procuring cause defined as the broker who began an uninterrupted chain of events that eventually resulted in the sale of that property. Buyer representation. We have subagency, buyer agency, dual agency, and designated agency. Subagency is when you have two different brokers, both of whom are representing. Subagency is when you have two different brokers, okay, both of whom are representing the seller. In a subagency, the cooperating selling broker is actually representing the seller, even though they are working with the buyer. The selling broker becomes an agent of the listing broker and a subagent to the seller. In a buyer agency, this is when the buyer brokerage agreement is a contract of employment, similar to a listing, except the buyer is the client. In a dual agency, this occurs when one licensee has both the seller and the buyer or landlord and the tenant as clients in the same transaction. The risk is unavoidable here since advice given to one client could actually represent disloyalty to the other. In a designated agency, this is where both parties are not represented by the same agent but are represented by different agents affiliated with the same broker. The transaction broker is a facilitator with no agency relationship to either party in a transaction. Working with a customer, when not in an agency relationship, a salesperson can perform ministerial acts such as showing properties, making factual representations about a property's condition, providing information about comparable sales, pointing out neighborhood amenities, providing information about schools, utilities, taxes, etc., locating lenders, surveyors, attorneys, etc. if needed, and preparing and presenting offers. When choosing and disclosing the agency role, know your role and company policies. For risk reduction, a licensee can minimize risks of violating laws by being familiar with broker policy and seek advice when needed, make full disclosure at the earliest possible times, provide written confirmations that disclosures were made, make certain that actions are consistent with the role chosen, treat third parties fairly and reveal all pertinent facts, and choose your roles wisely. The Brokerage Relationship and Real Estate Transaction Act, aka BRRETA. In BRRETA, we have the brokerage relationship, brokerage engagement, material facts, and ministerial facts. The BRRETA law is an act passed by Georgia's state legislature that went into effect in 1994 and was last revised in 2000. It prevents misunderstandings that the common law might cause in brokerage relationships. Brokerage is the occupation or business of the real estate broker. The definition you may come across is as follows. Under BRRETA, a brokerage is defined under Georgia law as anyone who is authorized to buy, sell, rent, manage, exchange, or auction real property for another in return for a fee. Simply stated, the brokerage business is the occupation of a real estate broker. Brokerage relationship is an agency or non-agency relationship between a broker and a client or customer. The definition you may come across is as follows. Under BRRETA, the brokerage relationship is the relationship that is formed as a result of the parties entering into a brokerage engagement. Brokerage engagement is an agency relationship between broker and client, which can be created only by written contract. The definition you may come across is as follows. Under BRRETA, the brokerage relationship is the relationship that is formed as a result of the parties entering into a brokerage engagement. Material facts are facts a party does not know and they could not reasonably discover and would want to know. Ministerial facts are those acts which do not require the licensee's professional judgment or skill. No agency relationship is created. Now as for the duties of a broker engaged by sellers or landlords. The broker shall perform according to the contract, promote the client's interest as far as seeking buyers at acceptable price and terms, timely presenting those offers, disclosing known material facts, advising clients to get legal help when needed, and timely accounting for money and valuables, as well as using care and diligence, abiding by all laws and rules, and keep confidentiality unless required by law. Now, with that being said, the broker must disclose to all parties any adverse material facts about the property and any adverse material facts about the neighborhood to a radius of 1 mile. Now, as for the duties of broker engaged by buyers or tenants, the broker shall perform according to the contract, promote the client's interest as far as seeking buyers at acceptable price and terms, timely presenting offers, they must present all offers, disclosing known material facts, advising the client to seek legal help when needed, and timely accounting for money or valuables. They would exercise skill and care, abide by all laws and rules, and keep confidentiality unless required by law. Now, with that being said, the broker must disclose information about the buyer's finances and whether the buyer plans to occupy the property. The broker is not liable for false information if he or she did not know it was false and did not reveal the source. Termination of agency relationships. If a contract does not contain a specific date of termination, it will terminate in 1 year. This is important. If a contract does not contain a specific date of termination, it will terminate in 1 year. The broker's duties include accounting for any undistributed funds or property, keeping information confidential as requested unless legally required to disclose or unless it has become public knowledge, the brokerage relationship disclosure. The broker must disclose the type of agency, whether or not the broker has other commitments that might be considered conflicts of interest, how the company receives and shares compensation, and that the client can request confidentiality. Dual agency. One can act as a dual agent, entered a brokerage engagement with both seller and buyer, or landlord and tenant in the same transaction, only by written consent. For it to be informed consent, it must contain description of the property, statement of the nature of dual agency, for example, two parties where interests may be adverse, statement that the agent will disclose all adverse material facts except when a client asks to be confidential, disclose any material relationships, and a statement that the client does not have to consent, statement that consent has to be read, understood, and agreed to voluntarily. Designated agency. Designated agency is when two agents are affiliated with the same broker, have clients who are involved in the same transaction. Broker policy may permit the broker to delegate to each of these agents the right to continue to give the clients the same full service they would owe as a single agency role. Transaction brokerage. Has no agency relationship with either party. They can perform ministerial acts, which again under BRRETA means ministerial acts are acts that a broker or affiliated licensee performs for a person or customer which do not require discretion or the exercise of judgment on the part of the licensee, i.e. preparing and conveying offers, locating draftsmen, architects, attorneys, or lenders.
And that's all I have for today's topic, folks. Thank you for studying with me, and don't forget to like and subscribe for more content.